Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installation into our Anti-Federalist Papers series going on number 49. So if you haven't gone back and watched 1 through 48, I would highly encourage you to do so, because understanding the Anti-Federalist Papers in addition to the Federalist Papers will provide you a very well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat or defend against any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. Like I said, we're going on to number 49. Now, there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both just in case you can't access one or the other for whatever infinite number of reasons. And if you haven't done so already, while you're out there looking, get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 49 is titled On Constitutional Conventions, Part 1. This compiler says the following essay is in two parts. The first is by Massachusetts, interesting pseudonym, and is reprinted from the Massachusetts Gazette of January 29th, 1788. And the second part was written by an old Whig and is taken from the New York Journal on November 27th, 1787. So here's the actual author, or the author of the actual Anti-Federalist paper, number 49. It says that the new Constitution cannot make a union of states, but only of individuals, and purposes the beginning of one new society. One new government in all matters is evident from these considerations, viz. It marks no line of distinction between separate state matters and what would of right come under the control of the powers ordained in a union of states. To say that no line could be drawn is giving me the argument. For what can be more absurd than to say that states are united where a general power is established that extends to all objects of government, i.e., all that exist among the people who make the compact? And is it not clear that Congress have the right by the Constitution to make general laws for proving all acts, records, proceedings, and the effect thereof in what are now called the states? Is it possible after this that any state act can exist or any public business be done without the direction and sanction of Congress or by virtue of some subordinate authority? If not, how in the nature of things can there be a union of states? Does not the uniting of states as states necessarily imply the existence of separate state powers? Again, the Constitution makes no consistent, adequate provision for amendments to be made to it by states as states. Not they who drew up the amendments, should any be made, but they who ratify them must be considered as making them. 3/4 of the legislatures of the several states, as they are now called, may ratify amendments, that is, if Congress see fit, but not without. Where is then any independent state authority recognized in the plan? And if there is no independent state authority, how can there be a union of states? But is it not a question of importance why the states in their present capacity cannot ratify the original? I mean, why the legislatures of the several states cannot do this business? I wish to be informed where to find the regular exercise and legal sanction of state power if the legislative authority of the state is set aside. Have the powers some other constitutional means by which they can give their united voice in state affairs? This leads me to observe that should the new Constitution be received as it stands, it can never be proved that it originated from any proper state authority, because there is no such authority recognized either in the form of it or in the mode fixed upon for its ratification. It says, quote, "We the people of the United States," etc., make this Constitution. But does this phrase, "we the people of the United States," provide that the people are acting in state character, or that the several states must of necessity exist with separate governments? Who that understands the subject will believe either. But no, the Committee on Style said, nope, the only reason we switched it from "we the United States" or "we the people of the individual different states voting to ratify the U.S. Constitution," the only reason they changed it from that to "we the people of the United States" was to save ink and paper. That's the only reason. It wasn't to suggest a nation or country or state or a singular unitary body of government. No, no, no. There's no need to worry about that. It was merely to save ink and paper. The plan does not acknowledge any constitutional state authority as necessary in the ratification of it. This work is to be done by a mere convention, only in consequence of mere recommendation, which does by no means amount to a proper state act, as no state act can exist independent of the supreme authority of the state, and this authority is out of the question in the ratification of the new Constitution. It clearly follows that the ratifying of it by a mere convention is no proper state business. To conclude, the people may make the original, but the people have no right to alter it. Congress may order this matter just as they please, and consequently have whom they please elected for governors or representatives, not of the states, but of the people, and not of the people as men, but as property. Signed, Massachusetts. I think that's how you pronounce it. Now we're going on to part 2 of this similar document, of this similar topic. It says here, "It appears to me that I was mistaken in supposing that we could so very easily make trial of this Constitution and again change it at our pleasure. The conventions of the several states cannot propose any alterations. They are only to give their assent and ratification. And after the Constitution is once ratified, it must remain fixed until 2/3 of both the houses of Congress shall deem it necessary to propose amendments. Or the legislatures of 2/3 of the several states shall make application to Congress for the calling a convention for proposing amendments, which amendments shall not be valid until they are ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as one or the other mode of ratification may be proposed by Congress." That's Article 5 of the U.S. Constitution. This appears to me to be only a cunning way of saying that no alteration shall ever be made, so that whether it is a good constitution or a bad constitution, it will remain forever unamended. Lycurgus, when he promulgated his laws to the Spartans, made them swear that they would make no alterations in them until he should return from a journey which he was then about to undertake. He chose never to return, and therefore no alteration could be made in his laws. The people were made to believe that they could make trial of his laws for a few months or years during his absence, and as soon as he returned, they could continue to observe them or reject at pleasure. Thus, this celebrated republic was in reality established by a trick. In like manner, the proposed Constitution holds out a prospect of being subject to be changed if it be found necessary or convenient to change it, but the conditions upon which an alteration can take place are such as in all probability will never exist. The consequence will be that when the Constitution is once established, it never can be altered or amended without some violent convulsion or civil war. I wonder if that ever came true. In order to rapidly change the understanding of the Union government and its relationship to the states. The conditions, I say, upon which any alterations can take place appear to me to be such as never will exist. 2/3 of both houses of Congress, or the legislatures of 2/3 of the states, must agree in desiring a convention to be called. This will probably never happen. But if it should happen, then the convention may agree to the amendments, or not, as they think right. And after all, 3/4 of the states must ratify the amendments. Before all this labyrinth can be traced to a conclusion, ages will revolve, and perhaps the great principles upon which our late glorious revolution was founded will be totally forgotten. I wonder if that ever came true. I'll give you a hint, it did. If the principles of liberty are not firmly fixed and established in the present Constitution, in vain may we hope for retrieving them hereafter. Once they're gone, they're virtually impossible to get back. Which is why virtually every founder, even Hamilton, said you have to resist the first encroachments. Otherwise, Madison said it explicitly, if you tolerate the first encroachments, then the citizenry will tolerate anything. People once possessed of power are always loath to part with it. I just need to keep my mouth shut in terms of interjections and let the primary sources speak for themselves. And we shall never find 2/3 of a Congress voting or proposing anything which shall derogate from their own authority and importance, or agreeing to give back to the people any part of those privileges which they have once parted with. So far from it, that the greater occasion there may be for a reformation, the less likelihood will there be of accomplishing it. The greater the abuse of power, the more obstinately is it always persisted in. As to any expectation of 2/3 of a legislature's concurring in such a request, it is it is, if possible, still more remote. The legislatures of the states will be but forms and shadows, and it will be the height of arrogance and presumption in them to turn their thoughts to such high subjects. After this Constitution is once established, it is too evident that we shall be obliged to fill up the offices of assemblymen and councillors as we do those of constables by appointing men to serve whether they will or not, and fining them if they refuse. The members thus appointed, as soon as they can hurry through a law or two for repairing highways or impounding cattle, will conclude the business of their sessions as suddenly as possible, that they may return to their own business. Their heads will not be perplexed with the great affairs of state. We need not expect 2/3 of them ever to interfere in so momentous a question as that of calling a continental convention. The different legislatures will have no communication with one another from the time of the new Constitution being ratified to the end of the world. Congress will be the great focus of power, as well as the great and only medium of communication from one state to another. The great and the wise, I apologize for my snarky attitude. It's just, when I read these, it turns my stomach. Because they knew what was going to happen in 1787. And it was imposed anyway. The great and the wise and the mighty will be in possession of places and offices. They will oppose all changes in favor of liberty. They will steadily pursue the acquisition of more and more power to themselves, their adherents. Signed, an old Whig. Excellent. So if you have any questions about what was said in number 49, maybe questions about what was said in preceding papers, or if there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so, regardless of the topic of the next lecture. Until I see y'all then, I bid you all farewell.